our next module. Statutory amendment to innocent spouse. I'm going to do just a quick review of innocent spouse and what the different options are available for innocent spouse. I know this is a review for most of you, so don't forget to put any questions you've got in your chat box, or if you have comments with other participants. I would be interested in how many of you are handling innocent spouse cases, and if you are handling them under the B factor, the C factor, or the F factor, and if it's not too confidential how you're doing with those. That would be good for the chat box. So here's the review on innocent spouse. You have B relief. I'm going to call it Bravo relief. No one ever gets B relief. And if you've ever gotten B relief in the last 5 years, please put that in the chat box. This is actual knowledge or either had no reason to know. The parties are living together and the government is in there and it's a bad return and they're not going to give that person innocent spouse relief very often. Then the middle one has to do with the divorced situation, and you do get some under that C relief, Charlie relief, I'll call it. 2015C, if you were separated or divorced for 12 months, when the relief is sought, you may qualify. There cannot be actual knowledge, but the joint return might have been under duress. That would be a reason to get innocent spouse in a divorce setting. So keep that one in mind. A lot of times you start out bringing the innocent spouse case under both the C, Charlie, and the F relief. And a lot of times you end up at the end of the day with the Foxtrot relief, the F relief. So let's look at F relief because that's what's our hot topic for today. Discretionary innocent spouse relief if inequitable. And that's creating a hardship on the innocent spouse. A lot of factors of hardship and no actual knowledge. If the IRS can prove actual knowledge, that's an affirmative defense under F or Foxtrot relief not to get innocent spouse relief. So that's your overview and your refresher. So where's our change? There's a 2-year statute of limitations for B and C relief. And in the years past, probably the last 10 years, the tax court litigation has been primarily in the areas of alimony, whether or not it's deductible and met all the requirements, the dependency exemptions, and innocent spouse. And a lot of it has been in the statute of limitations area. There's a statute on the Bravo and the C relief, but the IRS and the tax court were applying the statute of limitations for B and C to F or Foxtrot relief, and Congress undertook to do that in 2019 to change it and enacted 6015 F2, giving it a 10-year statute of limitations. So you might dust off some old files that maybe you'd told the person, I can't apply for your innocent spouse relief because it's too late. It's past the 2-year statute of limitations since the assessment of the tax. You also get de novo review if the IRS rules against you with the U.S. tax court if you petition the tax court for that relief. The statute of limitations under IRC section 6502 is generally 10 years from the assessment of the tax, the The F relief sought must be on unpaid tax to qualify for the 10-year statute. The claim for refund is still 2 years, so you can't claim a refund under this 10-year statute of limitations. Now we're to a hot topic on COVID and the TCJA effect on business valuation and divorce, one of my favorite topics. Let's just review the TCJA relief on effect on business valuation. It has to do with rates. Maximum C corporation rate went from 35% to 21%. 20% on qualified business income on pass-through entities. The result, additional cash flow. That could increase the value of the marital business in the divorce, and it also could provide extra money for the payment of child support and alimony. Then comes the real hot topic because of COVID, and that's the subsequent events, COVID being a subsequent event. Let's look at AICPA's statement on standards for valuation, SSVS 1. Generally, the valuation analyst should consider only circumstances existing at the valuation date. An event that could affect the value may occur subsequent to the valuation date, such as an occurrence is referenced as a subsequent event. That's what a subsequent event is. Subsequent events are indicative of conditions that were not known or knowable at the valuation date, including conditions that arose subsequent to the valuation date. The valuation would not be updated to reflect those events or conditions. I'm going to go on to the second slide on this because it also has part of the definition. Moreover, the valuation would typically not include a discussion of those events or conditions because a valuation is performed at a point in time, the valuation date. And the events described in this subparagraph occurring subsequent to that date are not relevant to the date determined as of that date. In situations in which a valuation is meaningful to the intended user beyond the valuation date, the events may be of such nature and significance as to warrant disclosure in a separate section of the report in order to keep users informed. In other words, an update to the report. So put in the chat box when you think we knew about the occurrence of COVID and that it might have an impact on restaurants closing. What date did we know that? Did we know that in December of 2019? Was it knowable in 2019 at the end of the year? This affects the business valuation reports for all of those divorces, I think, that happen, let's say, separations for the valuation date, December 1, 2019 forward. And here's how we deal with it. We deal with it with divisible property and asking the business valuator to make an update. So if you CPAs have clients that are going through divorce that had a valuation date for the business valuation prior to COVID, whenever that happened, then you want to get an addendum or an update under the subsequent events. And even if it's not considered a technical subsequent event, because someone decides we didn't know, I would at least then do an updated report under the divisible property law under the North Carolina General Statutes. North Carolina General Statute 50-20B4 defines divisible property post-separation. All appreciation and diminution in value of marital property and divisible property occurring after the date of separation and prior to the date of distribution. Aha, this allows you to update your report, notwithstanding SSVS 1, or to ask for your client to have an updated report to consider the devaluation that happened to so many businesses with COVID. I get excited when I think about getting these discounts, although it's been a lot to go through just to get discounts, hasn't it? So we go back and we get the expert to opine. Now, I've seen expert analyses on when we could have possibly known about COVID that goes back almost to early December of 2019. The average person and probably the average business valuator didn't have it, but maybe research would have shown and made that knowable. I'm an expert because I say I am. Don Henley, one of my favorites.